Hello, good morning everyone. I am May and Benjamin, your discussant at this moment. So what are the topics that we are going to tackle? First, we have working conditions for a special group of employees, which is the continuation of report of Ms. Ira Pamela. Next, we have labor relations, and the last one, we have unfair labor practices. Ms. Ira Pamela already discussed the Chapter 1 and Chapter 2. Now, let's proceed to Chapter 3, Employment of House Helpers. Under Article 139, this chapter shall apply to all persons rendering services in households for compensation. Domestic or household service shall mean service in the employer's home, which is usually necessary or desirable for the maintenance and enjoyment thereof, and includes ministering to the personal comfort and convenience of the members of the employer's household, including services of family drivers. Article 140, Contract of Domestic Service. The original contract of domestic service shall not last for more than 2 years, but it may be renewed for such periods as may be agreed upon by the parties. In Article 141, Minimum Wage, house helpers shall be paid the following minimum wage: 800 pesos a month for house helpers in Manila, Quezon, Pasay and Caloocan cities and municipalities of Makati, San Juan, Mandaluyong, Muntinlupa, Navotas, Malabon, Parañaque, Las Piñas, Pasig, Marikina, Valenzuela, Taguig, and Pateros in Metro Manila and highly urbanized cities. 650 pesos a month for those in other chartered cities and first-class municipalities, and 550 pesos a month for those in other municipalities, provided that the employer shall review the employment contracts of their house helpers every 3 years, with the end in view of improving the terms and conditions thereof. Provided further that those house helpers who are receiving at least 1,000 pesos shall cover by the Social Security system and be entitled to all the benefits provided thereunder. Article 142, Minimum Cash Wage. The minimum wage rates prescribed under this chapter shall be the basic cash wage, which shall be paid to the house helpers in addition to lodging, food, and medical attendance. Article 114, Assignment of Non-Household Work. No house helper shall be assigned to work in a commercial, industrial, or agricultural enterprise at a wage or salary rate lower than the provided for agricultural or non-agricultural workers as prescribed herein. Article 144, Opportunity for Education. If the house helper is under the age of 18 years, the employer shall give him or her an opportunity at least elementary education. The cost of education shall be part of the house helper's compensation, unless there is any stipulation to the contrary. Article 145, Treatment of House Helpers. The employer should treat the house helper in a just and humane manner. In no case shall physical violence be used upon the house helper. Article 146, Board, lodging, and medical attendance. The employer shall furnish the house helper free of charge suitable and sanitary living quarters, as well as the adequate food and medical attendance. Article 147, Indemnity for unjust termination of services. If the period of household service is fixed, neither the employer nor the house helper may terminate the contract before the expiration of term, except for a just cause. If the house helper is unjustly dismissed, he or she shall be paid the compensation already earned, plus that for 15 days by way of indemnity. If the house helper leaves without justifiable reason, he or she shall forfeit any unpaid salary due him or her not exceeding 15 days. Article 148, Service of Termination Notice. If the duration of the household service is not determined either in stipulation or by the nature of the service, the employer or the house helper may give notice to put an end to the relationship 5 days before the intended termination of the service. Article 149, Employment Certification. Upon the severance of the household service relations, the employer shall give the house helper a written statement of the nature and duration of the service and his or her efficiency and conduct as house helper. Article 150. Employment Record. The employer may keep such records as he may deem necessary to reflect the actual terms and conditions of employment of his house helper, which the latter shall authenticate by signature or thumb mark upon request of the employer. Next, we have Chapter 4, Employment of Home Workers. Under Article 151, Regulation of Industrial Home Workers. The employment of industrial home workers and field personnel should be regulated by the government through the appropriate regulations issued by the Secretary of Labor and the Employment to ensure the general welfare and protection of home workers and field personnel and the industries employing them. In Article 152, Regulations of Secretary of Labor, the regulations or orders to be issued pursuant of this chapter shall be designed to ensure the minimum terms and conditions of employment applicable to the industrial home workers or field personnel involved. Article 153, Distribution of Homework. For purposes of this chapter, the employer of home workers includes any person, natural or artificial, who, for his account or benefit, or on behalf of any person residing outside the country, directly or indirectly, or through an employee, agent, contractor, subcontractor, or any other person. Number 1. Delivers or causes to be delivered any goods, articles, or materials to be processed or fabricated in or about a home and thereafter to be returned or to be disposed of or distributed in accordance with his directions, or sells any goods, articles, or materials to be processed by fabricated in or about a home and then divides them after such processing or fabrication, either by himself or through some other person. Last, we have Chapter 5, Employment of Night Workers. Article 154, Coverage. This chapter should apply to all persons who shall be employed or permitted or suffered to work at night, except those employed in agriculture, stock raising, fishing, maritime transport, and inland navigation, during a period of not less than 7 consecutive hours, including the interval from midnight to 5 o'clock in the morning, to be determined by the Secretary of Labor and Employment after consulting the workers, representatives, labor organization, and employers. So what is night worker? It means any employed person whose work requires performance of a substantial number of hours of night work which exceeds a specified limit. This limit shall be fixed by the Secretary of Labor after consulting the workers' representatives, labor organizations, and employers. Article 155, Health Assessment. At their request, workers shall have the right to undergo a health assessment without charge and to receive advice on how to reduce or avoid health problems associated with their work before taking up an assignment as a night worker at regular intervals during such an assignment, and if they experience health problems during such an assignment which are not caused by factors other than the performance of a night work. With the exemption of finding of unfitness for night work, the findings of such assessment shall not be transmitted to others without the worker's consent and shall not be used to their detriment. Article 156. Mandatory facilities. Suitable first aid facilities shall be made available for workers performing night work, including arrangement where such works, where necessary, can be taken immediately to a place for appropriate treatment. The employers are likewise required to provide safe and healthful working conditions and adequate or reasonable facilities such as sleeping or resting quarters in the establishment and transportation from the work premises to the nearest point of their residence, subject to exceptions and guidelines to be provided by the DOLE. Article 157 Transfer. Night workers who are certified as unfit for night work due to health reasons should be transferred whenever practicable to a similar job or which they are fit to work. If such a transfer to a similar job is not practicable, these workers should be granted the same benefits as the other workers who are unable to work or to secure employment during that period. A night worker certified as temporarily unfit for night work should be given the same protection against dismissal or notice of dismissal as other workers who are prevented from working for the reasons of health. Article 158 Women night workers. Measures shall be taken to ensure that an alternative to night work is available to women workers who would not otherwise called upon the performance, such as before and after childbirth for a period of at least 16 weeks, which should be divided between the time before and after childbirth. For addition, before and after childbirth for a period of at least 16 weeks, which should be divided between the time before and after childbirth. For additional periods in respect of which medical certificate is produced stating the said additional periods are necessary for the health of the mother or child. During pregnancy. During a specified time beyond the period after childbirth is affixed pursuant to subparagraph above, the length of which should be determined by the DOLE after consulting the labor organizations and employers. During periods referred to in this article, a woman worker shall not be dismissed or given notice of dismissal except for just authorized causes provided for in this code that are not connected with pregnancy, childbirth, and child care responsibilities. A woman worker shall not lose the benefits regarding her status, seniority, and access to promotion which may attach to her regular night work position. Pregnant women and nursing mothers may be allowed to work at night only if a competent physician, other than the company physician, should certify their fitness to render night work and specify, in the case of pregnant employees, the period of pregnancy that they can safely work. The measures referred to in this article may include the transfer to day work for where it is possible, the provision of social security benefits or extension of paternity leave. The provisions of this article shall not have the effect of reducing the protection and benefits connected with maternity leave under existing law. Article 159 The compensation for night workers in the form of working time, pay or similar benefit shall recognize the exceptional nature of night works. Article 160 Social Services. Appropriate social services shall be provided for night workers and where necessary for workers performing night work. Article 161 Night work schedules. Before introducing work schedules requiring the services of night workers, the employer shall consult the workers' representatives' labor organization concerned on the details of such schedules and the forms of organization of night work that are best adapted to the establishment and its personnel, as well as on the occupational health measures and social services which are required. In establishment employing night workers, consultation should take place regularly. So now, let's proceed to my next topic, labor relations, title, policy and definitions. We have Chapter 1, Policy. Under Article 218, Declaration of Policy. It is the policy of the state to promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation as means of settling labor's industrial disputes, to promote free trade unionism as an instrument for the enhancement of democracy and the promotion of social justice and development, to foster the free and voluntary organization of a strong and united labor movement, to promote the enlightenment of workers concerning their rights and obligations as union members and as employees, to provide an adequate administrative machinery for expeditious settlement of labor or industrial disputes, to ensure a stable but dynamic and just industrial peace, and to ensure the participation of workers in decision and policy-making processes affecting their rights, duties, and welfare, to encourage a truly democratic method of regulating the relations between the employers and employees by means of agreements freely entered into through collective bargaining. No court or administrative agency or official shall have the power to set or fix wages, rates of pay, hours of work, or other terms and conditions of employment, except as otherwise provided under this code. Chapter 2 Definitions. Under Article 219, we have commissions means the National Labor Relations Commission or any of its divisions as the case may be as provided under this code. Bureau means the Bureau of Labor Relations or the Labor Relations definitions in the regional offices established under the Presidential Decree No. 1 in the Department of Labor. Board, the National Conciliation and Mediation Board established under Executive Order No. 126. Council means the tripartite voluntary arbitration advisory council established under Executive Order No. 126 as amended. Employer includes any person acting in the interest of an employer, directly or indirectly. The term shall not include any labor organization or any of its officers or agents except when acting as employer. Employee includes any person in the employ of an employer. The term shall not be limited to the employees of a particular employer, unless the code so implicitly states. It shall include an individual whose work has ceased as a result of or in connection with a current labor dispute or because of an unfair labor practice, if he has not obtained any other substantially equivalent and regular employment. Labor organization means any union or association of employees which exists in whole or in part of the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. Labor organizations, any union or association of employees which exists in whole or in part of the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. Legitimate labor organization, any labor organization duly registered with the Department of Labor and Employment and includes any branch of local thereof. Company union means any labor organization whose formation, function, or administration has been assisted by any act defined as unfair labor practice by this code. Bargaining representative, a legitimate labor organization or any officer or agent of such organization, whether or not employed by the employer. Unfair labor practice means an unfair labor practice is precisely defined by this code. Labor disputes include any controversy or matter concerning terms and conditions of employment or the association or presentation of persons in the negotiating, fixing, maintaining, changing, or arranging the terms and conditions of employment, regardless of whether the disputants stand in the proximate relation of employer and employee. Managerial employee is one who is vested with the powers or prerogatives to lay down and execute management policies in order to hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. Supervisory employees are those who, in the interest of the employer, effectively recommend, such as managerial actions, if the exercise of such authority is not merely routinary or clerical in nature but requires the use of independent judgment. All employees not falling within any of the above definitions are considered rank and file employees for purposes of this book. Voluntary arbitrator. Any persons accredited by the board as such or a person named or designated in the collective bargaining agreement by the parties to act as their voluntary arbitrator, or one chosen with or without the assistance of the National Conciliation and Mediation Board, pursuant to a selection produced agreed upon the collective bargaining agreement, or any official that may be authorized by the Secretary of Labor and Employment to act as a voluntary may be authorized by the Secretary of Labor and Employment to act as a voluntary arbitrator upon the written request and agreement of the parties to a labor disputes. Strike means any contemporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. Lockout. Any temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. International union disputes include all disputes or grievances arising from any violation of a disagreement over any provision of the Constitution and bylaws of a union, including any violations of the rights and conditions of union membership provided for in this code. Strike breaker. Any person who obstructs, impedes, or interferes with the force, violence, coercion, threats, or intimidation, any peaceful picketing affecting wages, hours, or the conditions of work, or in the exercise of the right of self-organization or collective bargaining. Strike area. The establishment, warehouse, depots, plants, or offices, including the sites or premises used as the runaway shops of the employer, is struck. Strike area means the establishment, warehouse, depots, plants, or offices, including the sites of premises used as the runaway shops of the employer, is struck against, as well as the immediate vicinity actually used by picketing strike involving to and fro before all points of entrance to and exit from said establishment.
And now, let's move on to the last part of my topic, title Unfair Labor Practices. Under Chapter 1, we have Concept. Article 258, Concept of Unfair Labor Practice and Procedure for Prosecution thereof. Unfair labor practices violate the constitutional right of workers and employees to self-organization, are inimical to the legitimate interests of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect, disrupt industrial peace, and hinder the promotion of healthy and stable labor management relations. Consequently, unfair labor practices are not only violations of the civil rights of both labor and management, but are also criminal offenses against the state which shall be subject to prosecution and punishment as is herein provided, subject to the exercise by the President or by the Secretary of Labor and Employment of the power vested in them by Articles 263 and 264 of this Code. The civil aspects of all cases involving unfair practices, which may include claims for actual, moral, exemplary, and other forms of damages, attorney's fees, and other affirmative relief, shall be under the jurisdiction of the labor arbiters. The labor arbiters shall give utmost priority to the hearing and resolution of all cases involving unfair labor practices. They shall resolve such cases within 30 calendar days from the time they are submitted for their decision. Recovery of civil liability in the administrative proceeding shall bar recovery under the Civil Code. No criminal prosecution under this title may be instituted without a final judgment finding that unfair labor practice was committed. Having been first obtained in the preceding paragraph, during the pendency of such administrative proceeding, the running of the period of prescription of the criminal offense herein penalized shall be considered interrupted, provided, however, that the final judgment in the administrative proceedings shall not be binding in the criminal case, nor be considered as evidence of guilt, but merely as proof of compliance of the requirements therein set forth. Chapter 2 Unfair Labor Practices of Employers. In Article 259, unfair labor practices of employers shall be unlawful for an employer to commit any of the following unfair labor practices: to interfere with, restrain, or coerce employees in the exercise of the right to self-organization; to require as condition of employment that a person or an employee shall join a labor organization or shall withdraw from one to which he belongs; to contract out services or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their right to self-organization; to initiate, dominate, assist, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to its or its organizers or supporters; to discriminate in regard to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. Nothing in this code or in any other law shall stop the parties from requiring membership in an or recognized collective bargaining agent as a condition for employment, except those employees who are already members of another union at the time of signing of the collective bargaining agreement. Employees of an appropriate bargaining unit who are not members of the recognized collective bargaining agent may be assessed as a reasonable fee equivalent to the dues and other fees paid by members of the recognized collective bargaining agent, if such non-union member accept the benefits under the collective bargaining agreement, provided that the individual authorization required under Article 242, paragraph of this code shall not apply to non-members of the recognized collective bargaining agent. To dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under this code. To violate the duty to bargain collectively as prescribed by this code. To pay negotiation or attorney's fees to the union or its officers or agents as part of a settlement of any issue in collective bargaining or any other dispute, or to violate a collective bargaining agreement. The provision of the preceding paragraph, notwithstanding, only the officers and agents of corporations, associations, or partnership who have actually participated in authorized or ratified unfair labor practices shall be held criminally liable. Last, Chapter 3 Unfair Labor Practices of Labor Organization. Article 260 Unfair labor practices of labor organization shall be unfair labor practice for a labor organization, its officers, agents, or representatives. To restrain or coerce employees in the exercise of their right to self-organization. However, a labor organization shall have the right to prescribe its own rules with respect to the acquisition or retention of membership. To cause or attempt to cause an employer to discriminate against any membership in such organization has been denied, or to terminate an employee on any ground other than the usual term and condition under which membership or continuation of membership is made available to other members. To violate the duty or refuse to bargain collectively with the employer, provided it is the representative of the employees. To cause or attempt to cause an employer to pay or deliver or agree to pay or deliver money or other things of value in the nature of an exaction for service which are not performed or not be performed, including the demand for fee for union negotiations. To ask for or accept negotiations or attorney's fee from employers as part of settlement of any issue in collective bargaining or any dispute, or to violate a collective bargaining agreement. The provisions of the preceding paragraph, notwithstanding only the officers, members of governing boards, representatives or agents or members of labor associations or organizations who have actually participated in authorized or ratified unfair labor practices shall held criminally liable. And that's the end of my topic. Thanks for listening.